Charlie, are we missing? No, we have a full house from the zoning standpoint. Tom, how are you looking?
Yeah, it was just gonna be myself and Judge Cutler. I see
Okay.
Cassie's here as well, so.
All right, great.
Are we expecting David or no?
He did say he accepted yes to the meetings, so I assume so.
Well, it's 7 o'clock or 7:03 too. So I would propose that we open the special meeting of the Zoning Board of Appeals. It's now 7:02. It's March 21st. And sitting as the Board of Appeals are Woody Chittick. Dave McMorris is not here yet. I'd like to very much wait for Matt, but nevertheless, we'll open it up. Matt Watkins, Lee Darst, Mike Dickey, and Charlie Higginson. Charlie's mute. Well, a couple of you are muted. And so I'd like to have a roll call vote. Cassandra, do we have any sense that Dave cannot make this meeting, or?
I don't believe so.
Okay, he's all right. So let's open the meeting just to get that procedural matter out of the way. We have a quorum. Woody Chittick, aye. Would anybody else like to join the meeting?
Lee Darst, aye.
Lee Darst, good for you.
Michael Dickey, aye.
Come on, Mike, don't be shy. Okay,
Matt Watkins,
and Charlie, you're muted. Could you unmute?
Now I'm unmuted, I think.
Yeah, now I can hear you. Okay, so this special meeting is to review the proposed bylaw amendments that will ultimately end up on the floor of town meeting in early May. And also sitting as invited and welcomed guests are Tom Callahan, who's chair of the or head or whatever chair of the zoning bylaw committee, and the Honorable Judith Cutler, Judge Cutler, who's kind of outside counsel as well as committee member, and Cassie Rosano, who is a committee member. So, but if you could be tolerant for a minute or so, because Dave as vice chair, Dave McMorris as vice chair is, my estimation, not only critical, but I'd like him to sort of be the master of ceremonies for a while.
He just sent me an email and said that he's to start without him, but that he's running about 15 minutes.
How many minutes late?
He said he'll be on by 7:15.
Huh.
So another 10 minutes or so.
Okay, well, okay, so we have before us, I would propose that we reluctantly not just delay this, but to sort of jump in. And I don't know, Tom, do you want to take our discussion numerically? And by that, I mean, you know, Articles 2 and ending up at Article 12, or actually Article 1 to 12, or?
I think when we spoke, I think what we'll do is the same approach we did with advisory and planning is we'll go through the easy ones first, and it'll be the order of Article 1, 3, 6, 8, 12, and then 2.
Okay.
And Cassandra has both the Judge Cutler's summary, which is going to be our starting document for discussion, and then we can bring up the text of the bylaws as needed. You're probably going to want to see some of the text, some of them you might not want to, but we have all of that. So Cassandra, if you want to start with the judge's summary for Articles 1 and 13.
Yes, just give me a second to pull that up.
She has far more talents in screen saving than do I, so. Screen sharing and everything. There we go. Okay. So the Judge Cutler had prepared this, and you know we're going to sort of tag team on this tonight. And this is a document that we used. This is a document we used with both planning and advisory. There was small tweaks done with the planning board, and we'll cover those as we get through them. But here is the summary of Article 1 and 13. If you note, something's echoing. I don't know if that's me or I'm wondering if everybody else could mute so there's no background noise. Anyway, so Article 1 is the authority and purpose article. Article 13 is other administrative provisions that have two, I think it's about amendment that has two short paragraphs. Article 13 would be deleted and it would be, its content would be merged into the new Article 1. So the main changes in housekeeping were, in Article 1 were housekeeping, editorial. The 3 bullet points at the top are somewhat self-explanatory for that. The only change in Article 1 is that we've added 3 bullet points to the stated purposes of the bylaw. I believe right now they go through A through G, so this would add 3 more to them. And again, these are self-explanatory. At the planning board hearing, the word opportunities after housing was changed to options. I was somewhat surprised we debated that, but that was made, and that's really the only change here. If you'd like to see the text, Cassandra, if you could bring up the text of 1.
Yes.
I don't know if you can see. I don't know how to split screen with 2 documents at the same time. But
Let me.
no. Okay, so there's the actual article itself, and as you can see down in the added purposes GH and I, the word has been changed to options. So it's consolidating, it's cleaning up, it's getting rid of unnecessary language and redundancies, which is a theme throughout the changes that are being brought forward for this spring. And again, 13 will be merged into this. It's no longer necessary as a standalone article. The planning board approved this article 6-0, advisory 8-0. So if you have any questions about this, I appreciate it if we could get your recommendation tonight.
So Tom, is this how it will be presented to the public at town meeting? Probably a good question for all of these. Like, is this is this what people who are there are going to be seeing and kind of deciphering, or is there?
Yeah, we're probably going to have both available on the screen of what we're doing now. We've talked about this at length. We did a slideshow for the public. We unveiled these to the public on February 27th, which is something that's never done before, but we wanted to make sure we roll these out early. And we did a slideshow, and at town meeting, we will present the introductory parts of that slideshow to just explain what we're doing and why. And then in that slideshow, we had a side-by-side comparison of the old text and the new text. And it ends up, in the end of the day, it's 52 pages. So we're not going to distribute 52 pages at town meeting, and everybody's being encouraged to go look at the bylaw committee's website where all of that is found. But probably at town meeting, we're going to present these summaries first and then follow up with the text. And for 3 or at least 3 of the 6 articles, these are pretty simple and non-controversial. The other ones may have some more issues where we'll probably focus on having the actual text of the bylaw on the screen more than the summary. But, we haven't gotten to a final idea how we're going to do this, but we hope to have some form of handout. For example, at the rec fair, we're going to have those first 9 introductory pages of the slideshow available, and then this summary is going to be available. because it's somewhat shorter and easy to hand out. So that's probably something we're going to do. The warrant itself will have the text of the articles as well, and those will be in print in front of people.
Okay, so we've all had a chance to study many of these, or most of them, and in a couple of cases we didn't get. Well, it's a bit of a work in progress. So wording is being tweaked as we go along. But in this one, I haven't seen any changes or any. Well,
Yeah,
I'm
other than
not
that, yeah,
lead the
other than
way
the
in
change
this
of the
one.
word opportunities to options, nothing has changed here, and nothing's anticipated to change.
How about the zoning board? Do you have any issues? This is essentially a merger of 1 and 13. That doesn't mean it's should be accepted without challenge or discussion.
Well, if I might clarify, it's not just merging the two sections.
Okay,
It's because Article 13 has one provision that we didn't feel was even necessary because it's covered by the statute, and that is how the zoning bylaw can be amended by the town. Of course it can, and there was no need to have that in there. And then in terms of the other provisions, basically nothing has changed as stated in the summary. The only real changes in substance are the addition of the 3 purposes to add on to the purposes that are already in the bylaw. And then there's a rewording of section 1 authority, which will replace section 1 and 1.2 and substitute for it. And it just basically clarifies the source of the zoning authority of the town. And there's nothing new or different, or it doesn't do anything terribly different other than achieve our purposes of trying to make it as concise and clear as possible and remove redundant and unnecessary language, as Tom mentioned.
okay. So board, questions of either Judge Cutler or Tom Callahan?
So the GH and I that were added, is there, is there like either a recent example or kind of a long-term initiative? That those, I guess, have we wrestled in the past with, not having GH and I in there, or?
Well,
No.
Yeah, go ahead, Judge. Go ahead.
I was going to say, it's not that you've wrestled in the past without having them, but they are helpful to incorporate here, where the town is going to be looking at more in the future, looking at more solar energy and climate resiliency regulations, where the town is looking to achieve multifamily housing to meet its obligations under the Housing Choice Act. And just generally putting in the reference to conserving natural resources and preventing pollution. It just buttresses not only the bylaw itself and the requirements of the bylaw, but also decisions of the boards where they say, is this consistent with the intent and purposes of the bylaw? So it probably adds another 3 arrows in the quiver of the boards, the various boards' abilities to administer their provisions under the bylaw, the responsibilities.
Yeah, I asked that not because I'm against GH or I by any means. They seem to make sense to me, but I realized at past town meetings, right, that there's a lot of conspiracy theories, right? And so if people look at, and this is maybe more of just, I think you guys have done a great job as much as you can with promoting and kind of reaching out to an audience that has interested in it. I just, somebody could take like for example, and say, hey, my use of the land doesn't quite jive with what they think is most appropriate, and that kind of tangent can go off. So I'm not against any of what you're presenting. I'm just kind of thinking out loud as to like, once we get to the point where it's being presented, kind of, hey, what's the issue? What's the proposal and what's the impact is kind of what is going to resonate most, I think, with folks that don't have much of a knowledge of bylaws, you know?
Well, I mean, we have a master plan and should be following it. And so that's why that's being added. We haven't had one before, so we're putting that in. I hear what you're saying, Matt, and I've been to enough town meetings to know that sometimes you can hear some crazy stuff, but we can't obsess ourselves planning for the crazy. We'll deal with it as it comes, but there's no dark secret agenda hidden behind these three. It's just bringing us into the modern world of three issues that we are compelled to deal with anyway.
Yeah, I mean, if I could just interject, we've had hearings, situations where people have said, the value of land and buildings is not within your purview, and it's helpful to go back to the old item C in this and say, yes, it is. In fact, our job is the quality of life but also the protection of property and values and lifestyle in this town. I mean, it's like every other town. I mean, that's what these are kind of zoning must-haves, but people are sometimes surprised that the zoning bylaws are rather broad in terms of quality and also economic, the values of your property. It's not just I own this property and I can do whatever I want with it.
Right, and to Matt's point too, just because we're referencing the master plan, it's saying encourage following the master plan. It doesn't mean the master plan automatically supersedes something that an individual, is doing
Right.
somewhere in town.
But on the other hand, I do think it helps to sort of say the zoning bylaws in the state is not just Massachusetts, Cohasset,
Yeah.
are really grounded in these very basic principles of quality.
Yep.
So I don't know. I mean, this is, to my mind, one of the easier ones.
It's easy.
So I would propose but if we have questions or want to challenge it, or just want more clarity, please. Have a way.
Well, all right.
If not, I would suggest, and I would also urge us to, let's hold off on our votes until we've
All right.
done everything. And there may be a couple of these easy ones that we can vote on tonight. And there may be, and I think there are maybe a couple of other amendments that we're going to want to ruminate over for a couple of weeks. We can vote on the 4th of April, but we don't have to hold everything off until the 4th of April.
No, we just want to make sure everybody's recommendations are in the printed warrant.
Yeah.
I was
I don't know what
taken
that deadline is, Tom.
It's I was taken a little taken aback this morning with a surprise that the select board is dealing with some of these articles tonight too. I thought they were not voting until the 4th, but the 4th is the deadline for decisions to get it into the printed warrant.
Okay, well, fortunately,
So
we
the
meet,
select
I guess,
board is
April.
also the select board is, if it wishes tonight, has free reign to vote on these first three ones that are easy, and then we're going to we want to be there
Yeah.
face to face to discuss the other ones with them. So, okay, I mean, that's fine. Planning voted all at the end. Advisory
At the end,
voted.
Tom, I'd like to
voted.
loop back and say, okay, now we've gone through 6 of these articles. And, are we comfortable with, let's say, the merger of 1 and 13, but if people want to take more time to think about it, fine. I think as we get to the trickier ones, a couple of people, myself included, would prefer to,
I expect that.
Do the board members have the copy of this, this language other than what's on the screen?
I don't think it was sent to us. Was it, Cassandra, or not?
The full,
The full
This-
text?
Text to
Yes.
the articles.
yes.
Yeah.
Okay, sorry.
Okay, so, yeah,
I
so
know
we
I've
should,
seen it. I just
yeah,
don't.
because there's a
remember where.
second page to this as well.
Yes, this
Yeah.
was all sent to them.
Okay. All right, well, I think there's a, I haven't heard a need for further explication or anything else. So why don't we move on, Tom, to the
Okay,
next topic, next.
all right, Cassandra, if we could go back to the summary, I hate to keep you jumping around. But
And I should say, David McMorris has joined us.
yes, I recognized his smiling face.
Yes, I know. Well, he's not smiling,
haven't-
but other than
No, it's
that,
funny with COVID, how, we haven't seen everybody in a long time. I'm glad to see everyone is looking well.
he, and I will say, and I've mentioned this in an email to the zoning board, but I have had an opportunity to attend, and Charlie has certainly as well. Most of the forums, I'll say forums, be crude about it. And I would ask Dave McMorris as our vice chair to really conduct more or less the meeting from here on out, because I have personal opinions that, while strongly felt, have not been subjected to the inquiry of my fellow board members, and I don't want to sort of prejudice anybody pro or con. So I'd like to sort of come in at the end of some of these, but not at the beginning. I think it's important that we have an open, free debate and don't worry about who's taking, whose stake is in the ground here. So Dave, would you mind being our sort of chair pro tem? Where is he? He's gone away again on my screen. Cassandra, have we lost him?
No, he's
No,
there.
I'm here.
Oh, you're
Can you-
there.
Can you hear me all right?
Yeah, oh, there you are. Okay.
Okay, I have a child getting ready to sleep in the bedroom next to me, so I have to keep my voice down.
Oh, okay, okay. Well, if you want to sub, we'll move to Charlie, but you're the vice chair. Anyway, so this is zoning article 3, and I'm going to let Dave kind of conduct the conversation and inquiry.
So this is Article 3 is the article that deals with our districts. Again, this is mostly housekeeping. We are not making any changes to our districts. It updates the list of our districts. We had one thing in there that we had identified as an overlay district that's not really an overlay district, so that's been removed.
Which one is that, Tom?
Judge Cutler, that was for the
They call it the cluster overlay district, but it
yeah,
is not an overlay district.
the residential cluster bylaw, which is Article 9, I think.
10.
So, we're just clarifying that with respect to the map. The map at the moment is the one that you see is multicolored with the districts is not completely up to date. It's missing the solar overlay, it's missing the transportation overlay on 3A, but there are maps that show those. So the article itself will reflect the fact that the current zoning map is going to be made up of actually a combination of the 3 maps, which is all fine because come fall, when we deal with the table of uses and we deal with, we may make some actual changes to districts. And going back 2 years to the bylaw working group, Woody will know we've talked about consolidating zoning districts in the harbor, and we may consolidate zoning districts on 3A. We're going to have to create a district on 3A to deal with the MBTA housing mandate. So the good thing is we'll have the map completely redone after the round of the fall town meeting articles and just do it at once rather than do it twice. The second 2 bullets down at the bottom shows some different edits that were made with respect to describing the boundaries of a lot. And I'm going to defer to Judge Cutler to explain those, but they're not really major substantive changes at all. Again, it's more clarity of what we're intending to do in our bylaw.
The exception to that pertains to the current rules that permit extending the use regulations from one district into another when a district boundary divides a lot at the time the district boundary is adopted. We were not able to find any real examples of this actually being the case, but this particular provision has been in the bylaw for quite some time, and it may be useful in the future if a new zoning district boundary were to divide an existing lot. So under the current rules, if you have a lot that's located in two different districts, you can extend the use regulations from one district into the second district, provided up to 50 feet or up to 200 feet with the Board of Appeals special permit, provided that you can meet the lot width and lot depth requirements of the district whose use regulations are being extended entirely on the portion of the lot that's located in that district. We took that provision, that requirement out of this language because it doesn't really conform to current zoning thinking, which is that when you have passive zoning requirements like yards or open space requirements that are not actually in use, you should be able to use the entirety of the lot, even though your use is governed in a different district. So we just took that one requirement out. Otherwise, it remains the same.
Any questions or comments from the board? Okay, let's move on.
Okay, thank you. The next is Article 6, which is the sign bylaw. As you know, our sign bylaw has quite an extensive list of definitions of different types of signs. Any substantive change here is to clarify the definition of a political or non-commercial sign to make sure it complies with constitutional rights. And then we want to expressly set out the exemptions for government signs. And then you'll see at the bottom a substantive change is that the bylaw right now does not have a height limit on a freestanding sign. So in theory, the sign on 3A could be as high as those things you see at highway intersections for gas stations. So we're putting in a reasonable height limit for signs in both the residential and the commercial districts. The thing about the political sign, Judge Cutler, I don't know if you want to add to that as you did the night advisories.
Sure. So right now, under the Cohasset zoning bylaw, you do allow quite generous you have quite generous regulations pertaining to political signs, and you define political signs, but more in the context of actual political issues or campaigning. So we have come up with a new definition, and actually, if you scroll it up a little bit, Cassandra, I think we can get to the change in the definition. Is that? No, I'm sorry, that would be in the article itself. I think you may, can you switch over to that so we can show the new definition?
Sure.
Anyhow, the idea is that we want to be consistent with the way that the First Amendment has been interpreted and applied to sign regulation. And basically, we're, as is now, political signs are allowed in all districts. Permanent political signs, temporary political signs are also allowed in all districts, but we want to divide the two. And if you keep moving up page, let's see if we can get to the definitions. I think they're sort of toward the end. Yeah, let's see. Yeah, keep going. Yeah, here we go. Political or non-commercial signs. So we're renaming political sign, political or non-commercial, and just it's a sign which expresses the view of the owner or occupant of a premises concerning political, religious, or ideological matters, or a sign containing any other expression of non-commercial speech protected by the United States Constitution. So basically, as I explained the other night, if the local liquor store, instead of putting up a sign advertising liquors that would otherwise be allowed, if instead they want to put up a sign that says save the whales, they may do so. So there's no content regulation under this bylaw. You can say whatever is, otherwise lawful speech on your, put any of that on your signs. And then temporary political signs do not require any kind of permit. They announce or advertise a person's candidacy for public office, or advocates for or against the election of a candidate, or advocates for a particular vote on a public issue to be determined by the electorate, or that is otherwise pending before a public body. So if somebody wants to stick a temporary sign on their property, or more than one temporary sign on their property, saying, vote no on the zoning recodifications, they are free to do so, and they keep those signs up for 60 days with no permit required. This is the other temporary signs, however, are limited to 30-day permits at a time with one extension. So they have a little less regulation than other temporary signs. So anyhow, we think with these changes, it should bring us well within the requirements to satisfy the First Amendment rules.
And this article was supported by planning 6-0 and advisory 8-0. And I forgot to mention that also the previous article, Article 3, was also 6-0 and 8-0 votes.
All right, members of the board, anyone have any questions, comments?
Judge Cutler, could you kind of, I'm all in favor of, signs and free expression. How's what happens if there's something that's offensive that's put up,
Well, then that's not protected by the First Amendment. So anything, obscene language cannot be put up, or obscene photos or pictures cannot be put up, and they can be ordered to be taken down.
But that would be what, general offense? I mean, where would a sign fall if it said no to abortion?
That's a political sign.
That's a political sign.
That's
a
representing their particular views.
personal view.
Right. And they can do that now. Let me tell you, if we didn't have this in here, and we said you can't have those kinds of signs, it wouldn't be enforceable. So, we're just trying to fit into, to make sure that the bylaw is not declared invalid for any reason on this ground.
Anyone else? Okay, thanks, Michael. Let's move on.
Could I ask one other question?
Sure.
In the fall or maybe next spring at the same time, will there be any other overhaul anticipated of other sections of the sign bylaw? Or not?
None are anticipated at the moment.
Okay.
One of the reasons of bringing this forward in this package was because it was sort of low-hanging fruit and easy to deal with and somewhat isolated to itself. So that's why we brought it forward now.
Yeah, I mean, I don't have any suggestions, but I will say that our sign bylaw is replete with all sorts of details, A to M or N and
Yep.
this and that, and if there was some way to, I don't want to sort of hurt anybody's or impair anybody's ability to advertise or signal things, but there's an awful lot of detail in there.
But one of the things we tried to do was reorganize it, because right now it's very confusing. You have to go from one spot to another.
Yeah,
And so what we tried to do was reorganize the existing regulations and clarify them. But yeah, I mean, at some point in time, you may want to have a study done of the kind of signage that you want and see if that fits in your regulations, or whether you need to revise those regulations. and
well,
have
is that reorganization coming to the town?
That reorganization is part of this article. So if you could, Cassie, if you could switch it back to the actual language of the warrant article.
Yeah, give me a minute. I had
Sure.
closed it
Sorry.
out in preparation for the next
Sorry.
one. That's okay.
So in this particular case, we have the whole reorganized and revised Article 6 set out in full. So this will be the way it reads. It will substitute for what's existing in the current bylaw. And what has happened is it's reorganized, it's updated, and certain provisions have been edited to clarify their meanings, but we haven't changed the requirements, except for the exempt signs, which certain signs are already exempt as a matter of law, but we also, I suppose I should put in there, that is a substantive change. We have expressly exempted signs erected and maintained by the town on any building or structure in use by the town, in addition to those that are federal government or state government. So that is something that wasn't in there before. The other thing is that we've taken out, there was a provision about enforcement and fines, which I think somehow got brought into this when it was switched over from a general bylaw to a zoning bylaw. We've taken that out because any violation of these requirements is a violation of the zoning bylaw, and the same fines and enforcement process would apply. And the other major change is as Tom mentioned, putting a height restriction on freestanding signs. There is a restriction on the height of signs located on a building. They can't be above, the top of it can't be above the top of the roof of the wall on which they're located, but there's nothing that says how high a freestanding sign is. So that's why we wanted to put that in there.
Let me ask one other question. It's just coming up to me, but under 6.1D, what about religious signs? Signs that either advertise, I don't know, food pantry. Well, food pantry is not religious, but you know what I mean. Sunday
Well, those are
services
accessory-
or
Yeah, those are accessory signs to the religious
Okay.
institution, and they're subject only to sign numbers and sizes the same as anything else. Now, a religious organization could, or an educational
yeah, the
organization.
historic society.
Well, not the historic, but the
Okay.
but a religious or educational use that may be otherwise exempt from certain regulation under the zoning bylaw due to section 3 of chapter 40A may claim that they are not subject to some of the more restrictive provisions on signs, and you would have to consider that.
Would you consider a church advertising services, Good Friday
That's an
services?
accessory,
with
that's an
flags?
accessory bulletin board type sign.
Yeah,
Yeah.
okay.
I mean, if they're in a residential district, they're gonna have to be smaller than if they were in a commercial district. But I'm sure many of these signs predate your sign bylaw.
Probably. And most of our churches are in residential districts, as you
Yeah.
would expect.
Yeah. And then if there are event signs that are off premises, come to the Christmas fair or something
Yeah,
like that.
yeah.
those are, those are different. That's a banner that's permitted for a certain period of time and locations that are
But
permitted.
there is some slack given to these other institutions that are not,
Well, if it's governmental, for example, a school would be something that is, exempt from regulation altogether if it's owned by the town or the Commonwealth, wouldn't have sign regulations apply. If it's a church, as I say, I think churches are dealt with in the same fashion that other exempt uses under Chapter 48 are dealt with. And you have to look at, is the restriction reasonable? And that would be something on a case by case basis.
yeah, and it's not really kind of carved out here, not that it has to be, but because it isn't now, but I just was wondering if religious and, or as you say, educational institutions should be just mentioned briefly.
Well, they will be actually, there's a whole slew of things that need to be mentioned when we get to Article 4. And one of them is to really expressly deal with exempt uses that are exempt under Chapter 48, Section 3. That would
Okay.
include religious and educational and agricultural and solar. And, there's a whole list, and we have to address those specifically in Article 4 anyway.
Okay, and that's what, the fall?
Right, yeah.
Yeah.
An overhaul of the table of uses is
Got it. Okay.
item 1 we're dealing with.
All right, I
beginning.
didn't mean to bog it down. I was
No,
just
that's all
wondering
right.
if this was
No,
too
no.
narrow. And
Well, now we want to save time we're getting into the 3 meaty ones, so. All right, the next one, Cassandra, if we could start with the summary for Article 8. As this board knows what Article 8 is with the non-conforming lots and uses and structures. This article is going to be presented to the town in 2 separate votes, 2 parts, and they're summarized here. The first part is a reform of the entirety of Article 8, and it's mostly in the nature of housekeeping, again, consolidation, housekeeping, getting rid of unnecessary language. And the part about the single lot exemption as it currently exists, it's just a relatively minor tweak to that. And then the definition of abandonment that is currently found in Article 2 is going to be brought into Article 8. One of our objectives is to try to consolidate definitions that are all over the bylaw into one article, but abandonment is the exception because it's very much applicable to Article 8. And you'll see, and then it's not only being moved, but it's being edited, and we'll get to that in a moment. The second step of the vote, the second separate vote, is then to truly reform the Cohasset version of the single lot exemption by bringing in a cutoff date. And that would be lots that are created before June 30, 2023. And what we have learned over the last 2 years of researching this, the bylaw group originally had pitched the idea of repealing Cohasset's version of the single lot exemption. We discovered that there is a Supreme Judicial Court case out there where discussed repeal of a very similar bylaw in Orleans. They ruled 30 years after the fact of the repeal that if the town had created extra grandfathering rights for somebody by its bylaw, which Orleans did and what we do, those rights will exist forever according to 48 Section 6, basic single lot exemption. And so whether we repeal, whether we amend, anyone who might have rights today under the current version of Cohasset single lot exemption will continue to have those rights. We cannot identify how many properties those are because you'd have to do a title search of each individual property to explore the issue of common ownership. So it would have to be dealt with on a case-by-case basis. But what the amendment would do in the second part of the vote is to cut off the creation of these extra grandfathering rights in the future. And in the future meeting, lots that are created by new subdivisions after June 30th, 2023. Now, we did some research. Our original bylaw in 1955 did cut off future, this grandfathering exception for lots created. Well, the lots had to be created before June, whatever, 1955. And in 1978, when we reformed our bylaw to conform with the new state zoning act, we abandoned that. And as you well know, the last court case was in like 2017 or 18, but a property on Atlantic Avenue. If I could paraphrase the court, they said that Cohasset has effectively abandoned the merger doctrine. So if someone has a lot that's in common ownership, there is no, it's open-ended as to when their rights can be exercised. The state zoning act, 48 section 6, does have a cutoff time. It's 5 years from the change or 5 years from January 1, 76. We're suggesting here just to put in a cutoff date to prevent new rights from accruing in the future. We are not affecting anybody who might have rights today. If we could scroll down a little, Cassandra, I don't know if this has the definition. No, it doesn't. Okay, so let's go to the text for a minute, if we could. And I will tell you, in the public forums, which were heavily populated by developers and discussions with the planning board and advisory committee, this has proven a lot less controversial than it was a year and a half ago when we had first toyed with the idea of repeal. That brought people out to one of our meetings, and that brought some controversy. So I think everybody sees the logic of making this change. But if we can go down, so first part of the vote is just a complete rewrite, consolidation, housekeeping of the existing Article 8. The existing single lot exemption is moved to 8.6. The change there is to make sure that that is just that the single lot exemption is applied to residential lots, as is the state single lot exemption. Ours seems to imply that commercial lots can take advantage of it, although I'm not aware that anybody has ever done that in Cohasset. And then if we're keeping the same minimum lot size to exercise that exception, everything would be the same. We go a little further down. And then abandonment. Abandonment would be, again, moving from Article 2 and be moving into Article 8. And then this is the rewrite of abandonment of the current definition here. And again, then the second part of the vote, which would be down there as C, would be to further amend the single lot exemption by putting in the cutoff date that the plan, a lot to take advantage of our exception, would have to be in existence as of June 30, 2023. Judge, I don't know if there's anything you want to add to that, but
just to again clarify that lots that are not covered by this sort of special additional protection you have would still be able to rely upon the protections of 48 section 6. So what it really affects are lots that are held in common ownership. They, after June 30th, 2023, if lots are created and held in common ownership and they're lawful at the time, but the town meeting amends the zoning to, say, increase the area or frontage so that both lots no longer meet the requirements, they will have to merge for zoning purposes the same as under state law. So this only really affects prospective lots and prospective changes in the bylaw that would make those lots non-conforming. It's far out there, but it does provide a cutoff, and we won't continuously have lots, you know, under the current regulation. If you have lots that are created in the future and there are future zoning amendments which make them unlawful, they are not required to merge. So this sort of brings it into the same mode as under the state law.
And Matt, to your point earlier today about presenting this to town meeting, we had some additional slides in our slideshow that got into the detail of what the single lot exemption is, how it operates under state law, how our bylaw compares to it. So, you know, to the extent there are people at town meeting who want to get into the weeds of the single lot exemption, which is difficult to explain even for people who are familiar with it, we'll be ready to do that. I think you folks deal with this article, you know it, but please ask any questions you'd like about it.
I have a question on the abandonment issue. I'll use an example.
Which one, the part that puts in the date?
No, the abandonment.
Oh, the
Okay.
abandonment, I'm sorry. Yeah, go ahead.
Proposed 8.7.
Yep.
Example is the Beechwood store.
Yep.
Which is now being converted into a general store and a couple of residences above.
Yep.
On the same non-conforming footprint as currently exists. That building was tied up for a significant period of time in probate. I don't see that probate issues are necessarily included in subsection C as a reason to extend the 2-year period.
Well, not specifically, but if you look at the last sentence, the special permit granting authority may extend the 2-year limit if it determines that extraordinary circumstances have prevented the use and maintenance of the non-conforming structure despite good faith efforts of the property owner. So that would be a consideration for the zoning board of appeals. If someone came in and said, you know what, my property is in probate, I can't touch it. Can you extend the 2-year period? This is not through any fault of my own. I would like to do something to it, but I can't. That would be something that the zoning board of appeals could determine as an extraordinary circumstance that, you know, is really unavoidable.
Okay, so
And
it seems to me that in that case, the representative of the estate would have to do so and not the purchaser. Because
Not the purchaser, no, it'd have to be the owner, right?
it always has to be, any application to any town board has to be by the owner or at least
Authorized.
with the authority of the owner.
now I understand that, but what I'm thinking is, you know, that property was tied up for a while.
Yeah.
The people that bought it with the intention of doing what they're doing, but if the estate hadn't come in and asked for an extension, the purchaser wouldn't be able to then apply to do what they wanted to do. Because
Well,
they're
it
not
has-
property owner.
Depends upon when the purchase, if the purchase is occurring while the property is in probate, then they would, you know, then he shouldn't purchase it unless he knows he can do what he wants to do. And one of those ways, if more than 2 years is passed, would be to, you know, get the seller to cooperate in getting an extension. Otherwise, the property is not worth what it's being asked for. It's an investment. You have to do your due diligence.
Yeah, and I would also presume that a purchaser will come in there if they have the authority of the owner to make an application in the first place, they probably have or should be clear with the owner that they have the authority to do everything that comes with that, including asking for an extension of time. But I don't know that this is different in, I don't have the current definition in front of me. I don't know if this is different in practice to what happens now. I don't think we, at present, have a hard 2-year rule, but there is room for exception.
Yeah, what I'm hearing though is that if people are, let's say, ignorant of the law, or as Dave says, you know, it's being executed. The will is being executed and it's taking a long while, and a year goes by, 2 years, 3 years go by, and somebody's living in Cleveland, Ohio, and all of a sudden it's been 4 years, and they have always intended to sell this property and always intended to whatever, see it developed. But if they miss the 2-year window, they can't do this retrospectively. Said it was tied up. The parent's
it's
will
still
was being executed, and it
If
took,
it's still tied up in probate, they could, sure.
Yeah.
I mean, let's look at this particular property. How did it get permission to do what it's doing? Somebody must have given them the permission because it took,
No, not necessarily. This is a pre-existing use. A pre-existing property.
well, nobody made the determination, then it was abandoned, so maybe the issue never came up. But
Right.
if the
It
building
didn't come
inspector
up.
had said the use here in Beechwood is abandoned, yeah, they would have had to ask for extension, and they would have, and the lengthy time of that particular probate would have been a great excuse for that. I guess we got lucky that nobody brought up the issue that the use had been abandoned. It had been
No, well, we
abandoned
did consider it,
for an
Tom.
awfully long time.
It
You
was,
you already have a 2-year limit in your definition. It calls for a 2-year limit on non-residential uses.
it was fortunate that the non-conforming use was residential and
That's 3 years.
the residence was within 2 years.
And
The other
here it's
piece-
3 years.
Yeah.
3 years under your current bylaw, and it stays here for 3 years.
Mhm. So that we got around that, and that the commercial use was a conforming use, so that wasn't an issue, because you
Mhm.
can't abandon a conforming use.
Right.
I mean, we don't want to try to create something that's open-ended.
No, I understand that, but I just want to make sure that we don't foreclose a good thing by,
Well, you know,
I just don't think all citizens understand, timing, 2-year to 3-year, the definition of abandonment. I know it's in our bylaws, and I know that I would agree that they should have somebody do homework if they are not able to themselves, but there are situations where things sit there and they're, okay,
I
there
mean,
is a window. You're basically saying there's a window, though.
There's an existing window. We have not made a change in the existing time frame. We have only added a provision that allows for an extension of that time if the Board of Appeals believes that it's appropriate.
But I couldn't go into the zoning board and say, gee, I meant to, I should have appealed 3 years ago, but I didn't. So would you grant me a retrospective? No, I mean, I'm not
Well,
trying to,
No, but you know,
Trouble,
Woody,
I'm just-
if you own property, you have to sort of pay attention, like, you
Yeah,
have to
okay.
pay your mortgage, you can't have someone tap you on the shoulder every 5 minutes,
yeah,
I mean, we have so many examples in the law where we have deadlines that we have to operate under, and we have them for reasons. And the adage that ignorance of the law is no excuse has to.
well,
has
I'm
to-
playing devil's advocate. I'm not,
Yeah.
I'm
I know,
not,
I know, but we can't just throw things out of the water, out the window just because one property owner wasn't on top of their game. I mean, then
okay,
the
so the
bylaw
answer is,
the bylaw becomes useless at that
a
point.
2-year or 3-year, depending on the use window, and if you or your agents or the former owner or anything else, I mean, didn't act, your title search should have picked this up if you're the new owner,
Yeah, you just have to be more
presumably.
cautious. You have to be more cautious if you own non-conforming property or you're buying non-conforming property. They're just extra. You get special protections, but you also have special rules to maintain those protections.
I have to absent myself for a minute, so I'll be back shortly.
Okay,
This
I've got
grandfather
one
thing,
piece of housekeeping. Well, no, I want to hear from the others on the board. We're in section 8, if you will. It's ordered, but pretty much intact.
Yeah, the first part of this vote is just really a reorganization and cleanup of unnecessary language. It's substantively the same.
Well, board, what other either sections of proposed Article 8 or whatever would you like to sort of raise as issues or inquiries or whatever?
There's really nothing. I mean,
Well,
Well, let's hear from the board. I mean, I don't know.
oh, I'm sorry. I thought that was.
No, I'm
questions for
asking
everybody.
the zoning board what it
Oh,
may
all
have
right. Sure.
individually as issues or just need for clarity or just understanding. I hear a lot of silence. That could be good news.
You said we're changing the date to June 30th. We're, we
We're
wouldn't. be-
inserting a date that doesn't exist now to cut this off at some point, so it's not. The exception to the single lot exemption is not exercisable in Cohasset ad nauseum forever and ever. And we had such a cutoff date once, we abandoned it in 1978, and the court has told us where, we have a problem.
And Tom, is to confirm, this is just as a go forward basis, the folks are all grandfathered in, is that right?
Well, well, again, you would, that Supreme Judicial Court case said that if a town had created extra grandfathering rights, which we have done and which Orleans had once done, those rights are preserved even if the town subsequently repeals and amends the extra rights provision.
For residential lots.
For residential lots. So those folks, and again, in the case of that court case, it was a property that could have been built on in their exception in 1970. They repealed their bylaw in 71. The Supreme Judicial Court rules in the year 2000 that lot still has the rights it once had from 1970. So it will be case by case. People will have to come up to us and show that whether they meet the exception of our bylaw. Now, when this came up, when we talked about repeal, there was a property owner who came up and he thought his rights were being removed. And after that meeting, when you researched his lots, they were not of sufficient size that they could take advantage of the Cohasset's unique exception. So they don't have any rights, did not have any rights, and won't going forward. But another lot, like the one on Atlantic Avenue that was the subject of the court case, they had rights under our unique exception. And let's say it wasn't built on yet, they would still have those rights to build after this amendment. It is for newly created lots that we are cutting off this ability to exercise this exception.
Regardless of the zoning district it's in. Right?
In residential districts.
In residential
Well,
districts. Well, it doesn't
well-
exist in commercial districts, Woody. The state law, the single lot exemption in state law it says it's limited to lots that are zoned for 1 or 2 family use.
Well, what if I have a house, we have 35 such structures, pre-existing homes in commercial districts in town, best I could figure out, plus or minus.
Where?
And they were created, God knows when, in the 1800s, most likely.
Lots
And-
or housing.
And probably just statistically, some of them, not all of them, have a registered second lot. It looks like a single lot, but they really own 2 lots that are in there. I mean, I don't know which ones, because you'd have to do all the title searching, but just assume I live on the Highway Business District in a house that was built in 1880, and my grandfather decided to register 2 lots. Am I afforded the protection, or do I lose the protection?
You don't have the protection because, remember, the other part of our bylaws, subparagraph A of the existing 8.3, first incorporates Chapter 40A, Section 6, which is the basic single lot exemption. And that refers to lots that are zoned for 1 or 2 family use. If they are not zoned for that, my argument would be they don't have the exemption at all under state law. And we certainly don't override it because we incorporate that part of state law into our bylaw.
Okay, I would agree that they're not zoned, or this hypothetical lot is not zoned as a residential zone, but it's got a pre-existing home on it.
Well, then that's not governed by this exception. That's got a pre-existing non-conforming residential structure on it.
And
That
I've
has a
got 2
different,
lots.
that's a different, but it has an adjoining lot it's not covered by state law and it's not covered by this. You have to have the 2 vacant lots. Otherwise, this doesn't work.
2 vacant lots or 1 vacant lot?
You mean the second, you mean what, there's
Yeah.
a house on one lot and then
Yeah.
there's adjoining lot. So they're in common ownership,
Right.
right? They have a pre-existing non-conforming structure, but that in order to maintain its value as a valid pre-existing non-conforming structure, it had to meet whatever the requirement was at the time that it was built.
Okay, and let's say it's 1880, so there's no requirement.
All right, so there's no requirement. So then you go to the 1955 bylaw,
Yeah,
and it would have been protected at that time if it met the requirements and had frontage.
yeah, okay.
And that stays forever.
That stays forever, even if it's in a commercial district.
If it's a lot for, if that lot can be used for single, if it wasn't already used and the new zoning comes in and it's not for residential purposes, they don't have any protections. There are none.
It was always intended to be, I'm making this up, but it was
an
always
intention.
intended to be a house for mom and dad next door.
Yeah, but that, I mean, you can have an intention, but if you don't act on it and circumstances change, sometimes you miss the boat. I mean, you know, how long are you supposed to hold it open for them?
Well, in this town, some of these have been held open 70, 80 years.
Well,
I mean, registered in the 30s.
yeah. And that may be, and they lucked out and they're able to continue on, but they also may not meet the current requirement of having the minimum lot size. They
Yeah.
may be smaller, in which
You
case
can
they,
count on it that they don't meet it.
if they
I'm just
don't meet
thinking
it,
of people going back 2 years at our town meeting prior to your appearance in the scene. I mean, you know, these people came out with these heartrending stories about this is my legacy or my inheritance from my grandfather, and we were always told we could build on it, and now you're taking it away and blah, blah, blah.
we're not taking away any rights that
Okay.
already exist, Woody.
All right,
Those rights continue just as they are today and as they have been.
but I'm
What we're
thinking,
talking, and we're not even taking rights away from future people, definite rights away, because the way this operates is after June 30th, if you create new lots
yeah,
and you hold them in common, and later the zoning changes, before you've had a chance to either build on them and put them in separate ownership, the zoning changes that makes them non-conforming.
I don't have a problem with new lots. I'm thinking of people being concerned about a pre-existing lot, pre-existing the zoning bylaw lot,
They're governed by the bylaw as it is today.
even if they're on the highway.
What do you mean if they're on the highway?
Well, there are houses in the highway business district.
Houses aren't governed by this section 8.6.
Okay,
Those are pre-existing non-conforming residential structures, and they're governed by chapter 40A. They're protected. And they have, if there's going to be major changes or substantial additions or whatever, they're going to have to come before the zoning board of
of course,
appeals.
I'm thinking about the vacant lot next door. We can move on. but-
I don't, well, I think the bottom line is the vacant lot in a commercial district is not going to be having a house built on it, period. Under any permutation of the law, state law.
It's
or
a legal
town-
lot, but not a legal house lot or
Exactly.
residential lot.
Exactly.
Correct.
Okay,
And with all the, you know, there's portions of 3A that have houses on it that I believe are residential zoned. I'd love to
no,
talk
you're
to.
right, but there are some that
All right,
there
well,
are
that's
some
fine.
that
And
are smack. dab
that's
in the middle of the highway.
something when we look at the districts, maybe we address
No,
that.
no, it's, you know what I mean? Somebody built something honestly in the 1800s.
Okay, all right, all right.
You know, a mile away from something, you couldn't encompass it.
Okay, so
They're
All
just an anomaly.
these
Accepted.
changes to Article 8 were supported by Planning 6-0 and Advisory 8-0. And so,
Before we move on, I've got one thing. I said I'd shut up and I haven't. 8.10, old 8.10.
Yes.
allows a temporary structure for 1 year, no more. That doesn't, have you reinserted that or included that? Because I think that is a reasonable and not very offensive,
Right, but it doesn't belong in this article. And so what we have to do, and I have my notes from that, is we have to figure out how we can somehow, keep that provision and insert it into Article 4 or something. I'm not sure
Okay.
exactly how that works, but it seems to me we could include that since we're amending Article 8, and that Article 8 already contains that provision. It doesn't belong there. It belongs somewhere else. And so we have to sort of.
I would like to see it in whatever you're presenting to town meeting. If you remove one thing that makes sense, rather than say, we'll take care of it later, a
No,
year
no.
from now.
No, that's not what I'm saying. Right, that's not what I'm saying. I'm saying in the article, in the motion,
Mhm.
seems to me, we're gonna have to address that and fit into a different.
Okay, fine, if it's addressed and.
It'll,
you know,
it'll be it'll be a section within the redone Article 4.
Okay, so Article 4 is coming before the town meeting, redone.
Article 4 will be that both the table of area is going to be redone, and then the sections within it will be redone and.
Well, we can get at this later. I'm very uncomfortable about taking something out that belongs somewhere else and then just eliminating it.
I agree with you. We're gonna have to keep that language. I'd rather not keep it under Article 8. I'd rather insert it into.
I
Article.
agree,
Yeah.
I agree, but just don't, it could go into cyberspace for a year or two, for all I know. Anyway,
we're
let's
talk-
move
we're
on.
talk-
I
we're
mean,
talking
I'd
6
like to
months.
see 810
Yeah, 810.
somewhere.
810 will return.
Okay. But
And
not
it'll-
later, but for this
No,
town meeting. If we're taking it out for this town meeting, put it somewhere else for this town meeting.
I think we can give it a temporary home.
Yeah, temporary home, that's fine,
Mhm.
as long as
Okay.
it's there.
All right. Okay, so the next
Anything
one.
else on Article 8?
Yeah, I'm sorry, Dave.
Any board members have any more questions, comments? All right, let's move on, Tom.
All right, the next is Article 12, which is our administrative and enforcement article. And just make a quick note to myself. All right. So Article 12, the main changes coming here is, there's, again, we'll get to the text, there's been some rewriting. 12.1 has been rewritten a bit, and, it's, if you read the existing 12.1, I've always thought of it as a convoluted, confusing mess. But so a lot of this is done to bring clarity and cleaning up language. The first thing is about the fines. Currently under the bylaw, the maximum fine is $100 per day. As we know, our two boards, planning and zoning, can't issue fines, only the building inspector can. The maximum on state law is $300. Under our Concom bylaw, they can issue a $300 fine. I think the Board of Health can issue a $300 fine. So we are proposing to increase to the state maximum. But again, it's only the building inspector who has the power to actually impose a fine. There are new site plan review requirements that I'll have the judge go over, and then that's, again, and there's some changes in terminology and everything, but it's made to make our site plan review process clearer. And let's scroll down a little bit, Cassandra, if we could. Yeah, this is all about the site plan. So let me turn it over to the judge to explain the changes to site plan review.
Yeah, so it just expands site plan review requirements a bit more than it is now, and hopefully makes the process a little easier for people to understand and follow and deal with. So the planning board would still be the site plan review authority. It would apply, site plan review would apply to all commercial, industrial, and multifamily uses when either a new building is proposed, there's a substantial alteration of a building proposed, a change in use is proposed that results in additional parking requirements, or there's a substantial alteration of the parking or access area being proposed. And then you go down up one level, I think. Yeah, so we have included in there an explanation by what we mean by a substantial alteration of a building or group of buildings. It's one that results in an increase of 500 square feet or 10% of the existing gross floor area, whichever is more. And if it's less than that, site plan review is not applicable. Substantial alteration of parking, loading, or vehicular access is a change in the layout or location of the parking, loading, or access driveways, or an increase of 500 square feet or more of the area of the lot devoted to parking, loading, or vehicular circulation. One of the things that came up during the public hearing was, well, you know, what if it's just a small little thing? And even though it's 500 square feet, you're really not making big changes. And the idea is the planning board does have authority under this provision to adopt rules and regulations for administration of site plan review. And the planning board can determine that something is a minor change and require less information, perhaps less requirements than it would for something of a larger magnitude. So I think that would do it. The new provisions limit the planning board's review only to the development features that relate to things like site drainage or sanitary sewage or screening, convenience and safety of the circulation and parking, and compliance with the applicable zoning bylaw requirements for things like setbacks, areas, and numbers of parking spaces. So in other words, it's a physical, it's the physical layout of the site plan, not necessarily the design of the building and so forth. Want to make sure things are done so that they're safe and reduce impacts on abutting property owners and so forth. But it's not a full-scale design review situation. Additionally, go down just a little further on this list. So there's a limit of 75 days within which the planning board has to complete its site plan review and issue a decision, or otherwise the site plan is deemed approved. And there's only 3 reasons why the planning board can disapprove a site plan. First, if the application is incomplete, or second, the proposal doesn't comply with the other zoning bylaw requirements, or 3, there's no reasonable conditions the planning board can come up with that would reduce significant detrimental health and safety impacts from the proposed site development. So it'd have to be pretty bad situation where there really is no reasonable solution that can be imposed. And once the planning board issues site plan review, the building inspector can't issue a building permit unless the site plan review is done and the conditions and the proposed development is in compliance with those conditions.
Cassandra, can we put up the text to the actual bylaw? Please. So there is the new section 1, which I believe is very much a combination of the existing 1 and 2. And you see the added fine provision in D.
Oh, yeah, and one change I think that we made during the planning board public hearing, in A, that first sentence would be deleted.
Which was that?
In A, that first sentence requiring the building permit is being
Oh, yeah.
deleted because it's
Correct.
not always applicable. And I think Woody had pointed that out.
Yeah.
So that's actually being deleted.
Yeah, let's just make sure we get that in the
Mhm.
text for tomorrow, because planning has not voted on this one yet. In deference to you guys and to advisory. Advisory was 8-0 on this one.
To be fair to the board, this is some legacy wording. There's no question that this was not sort of invented or inserted by the current bylaw committee, but this is an opportunity to clear up an anomaly, because as we all know, a structure could be a mailbox or a, light pole or a tennis, I mean, it could be all sorts of things. And
Well,
that isn't, a lot of those structures are not buildings, and they're not subject to building permits. I don't think we would
okay,
want.
well, that's why that sentence is coming out. the
Right, I
first
think it's
sentence.
great.
And I think
it's-
in the fall, our discussions over the last couple of days about this, in the fall, there will be further changes to the definitions in Article 2. We need to revisit the definition of structure,
Oh, absolutely.
because maybe, we identify things like mailboxes and flagpoles and fences as something other than not equated to a building, and come up with some other terminology for it. All right, if we can go scroll down again further.
Okay, hold on.
Yep. Sorry.
This is a parallel issue, but I think it's a significant one, and I think it needs to be addressed. And I would prefer that it be addressed soon. Under subsection E, anyone aggrieved by the issuance of a building permit may appeal within 30 days of the building permit being issued. The way a building permit is made known to the public under the general bylaws is they are published in a newspaper of general circulation.
Yeah.
The town of
Which is-
Cohasset does not do that. The town of Cohasset publishes the building permits on the town website. And we've had a couple of people already who have missed the deadline and say, I never had proper notice. And they're
Yep.
right, they didn't. Fortunately, they found out by other means, so they had actual notice and missed the deadline. But this is a serious problem. If we're going to do it by publishing on the website weekly, then what is it, 80.1 of the general bylaws needs to be changed.
What is it? General bylaws 81, 80.1?
80.1, 80-1.
All right. I mean,
Yeah, the town can do a number of things in that regard. I mean, you can post the property and say that a building permit has been applied for so that people are notified. There are other towns, I think it's, I want to say Wellesley, that has pretty extensive notification requirements for abutters and, people in the.
Yeah, I think that's true. The problem is that the method that we've chosen in our bylaws is not the method that we use.
yeah,
That, we're not
yeah,
dealing with that at this town meeting, but that's something that probably should be considered.
we will ask for your help in making sure the select board doesn't have a problem with our committee delving into the general bylaw. They're very conscious of our scope and don't want us going, but we can easily explain that this is tied into the zoning bylaw, and we need to fix it. And that's like a lot of other things. We're getting away from paper applications. We're getting away from newspapers as sources of notices. So, we should look through our entire general and zoning bylaw to make sure we're up, we're in the 21st century.
Yeah, I searched newspaper under a general bylaw. It comes up at least 7 times.
Yeah, all right. Yeah, that's a good point. I wasn't aware of that. So good
I think
point.
that's in the statutes too. I think there's a lot of places that has to be dealt with, yes.
Well, think about it as the point Dave's making. I mean, if the town is not following its own bylaw, I think there's eminent reasons for appeal. And as Dave said, we have gone through this a few times, and I am bound and determined not to continue that.
All right. Well, again, the bylaw committee is not charged to go into the general bylaw, but certainly will help. We will help get it put before the fall town meeting. But somebody needs to write what you want to see happen, and then we can run it
I would
by.
urge you to concentrate on this article and think about amending this article the way it's written right
To do
now before
what?
us.
To do what? I mean, one of the points of E and other parts of these changes is to conform to state law and what the state law requires. And if Judge Cutler just mentioned that the state law is still saying newspaper, it's a much bigger problem than we're going to solve here in the town of
I
Cohasset.
don't have a problem with E the way it's written. I have a problem with the general bylaw the way it's written.
Yeah, that's a different issue, yes.
And, you know, Woody, to your point, if somebody appeals this, yeah, then the courts are going to be confronted with the fact that the state law and town bylaws are all behind the times by relying on newspapers that no longer exist. And
The
it'll
issue
be-
would come up, the issue would come up if somebody missed the 30-day deadline after the building permit was issued because they didn't get proper notice. And they would come, if they came to the zoning board of appeals and the zoning board, and it was raised by the, let's say, the property owner who had the building, that the board would have no jurisdiction because it was beyond the 30 days. Then it would be up to the Board of Appeals to determine, well, when did this person have notice realistically? And did they really, you know, did they just miss it because they, you know, they missed the boat? Or was it really something where with any kind of due diligence, they couldn't have known? And that's going to be the Board of Appeals determination.
Yeah, but we don't want to do that. That's
No,
not
I know
our-
you don't want to do that. I know you don't want to do that. So if you need the general bylaws clarified or fixed, I think, you know, that's something you really do need to raise to the selectmen.
Okay, we will.
Yeah.
Okay. anybody
So,
else
so
have
what
anything?
happens here if the building inspector does not respond in writing?
Okay, if there's a zoning enforcement request, and I know we've had this discussion and
Yeah.
I've done further research, there is a case decided by the appeals court way back in 2002, and it has been followed thereafter by further courts. Basically, says there's nothing in chapter 40A, section 7 and 8 that requires the building inspector to reply in writing to a zoning enforcement request. You're saying this statute says if there's an enforcement request, the building inspector, you know, shall reply and give their reasons within 14 days. But the courts have said that's directory, not mandatory. The important thing is that the building inspector, it's when the building inspector issues the written order or the written response denying the request or taking
That
action.
a
That is the-
non-action is not a denial.
It's not a denial. There's no constructive denial that's taken from a failure to respond.
Yeah, but our bylaw says there is
No,
under present 12(2) B and C.
but the appeals court also has determined that, and so has the SJC, that the procedural aspects of chapter 40A are comprehensive and controlled. So that prevents towns from altering those procedures. So if, you know, so what
Towns
would
can be more liberal than.
no,
in
they
some
can't,
respects.
not in the procedures, any more than the appeal from the building inspector's issuance of a building permit. You can't put in the bylaw that it's 60 days or 45 days. You need to follow what the zoning act says. Now you have indicated that there may be situations where somebody has submitted an enforcement request. There's radio silence, can't get the building inspector to respond. Well, what is it that they are appealing from? They're appealing from the building inspector doing nothing, not denying their request, not taking an action on the request that they are aggrieved by. They have their aggrievement is that the building inspector hasn't responded to them. That is a personnel matter. There could be perfectly good reasons why they're not being responded to. They may live on the other side of town and don't really have an interest, and the building inspector has more important things to do. This is not an aggrieved person.
Yeah, but
Yeah,
most
that-
of what we get is a immediate abutter. We
And
don't have
how
somebody on
long,
the other side of town. Come
and when
on.
do they appeal?
What do they appeal?
When do
There's-
they appeal?
When?
What is it? Yeah, when and what?
My reading, it would be that if the building inspector does not render an opinion within 14 days, it's essentially a denial. And
But that is, the courts have said that is not true. It is not a constructive denial. The statute does not provide for that.
Well, so what remedy does the aggrieved party have?
It's a political, it's an HR business. It's going to their enforcement, or rather their appointing
Oh,
authority.
okay, we
saying
part
building
company.
inspector's not
Here,
doing-
here I will go public if I have to, but
Well,
I
you
think
may
this
go
is taking a basic fundamental right of a
Woody.
citizen away.
It's not taking a fundamental, if you'd let me finish what I was going to say to you. The statute is pretty clear. There is no basis to appeal a failure of the building inspector to respond in writing to a request. And without that written response, there is nothing that is appealable. However, if somebody were to come to the board because perhaps they made repeated requests or what have you, no response, and they appeal to the board, they're not appealing a denial, they're appealing the failure of the building inspector to act. If the Board of Appeals determines that it wants to hear that, all right, and no one raises this as a jurisdictional issue, you go ahead and decide what you're going to decide, but you've waived the right on defense to say that there was no jurisdiction for this appeal, and so does the person requesting enforcement. So it doesn't do them any particular favor. If I'll give an example, somebody comes in and they've requested the building inspector to enforce the zoning bylaw on their next door neighbor's property and says, you know, the swimming pool is, or that would be it. They're using it for a business use, and it's not allowed under the zoning bylaw. Okay, and the building inspector doesn't respond to them or do anything in writing. He may have told them verbally, but that's not appealable either. But if he doesn't do it in writing and there's nothing appealable, and yet the abutter appeals anyway, and the board holds a hearing, and the property owner who is claimed to be in violation of the zoning bylaw appears before the board and says, there has been no written decision by the building inspector. There's nothing to appeal here. This board has no jurisdiction to entertain this appeal. And the board continues anyway and makes a decision and orders the building inspector to fine the person or orders the property owner to cease what they're doing. And that property owner appeals. There's no defense there. There is no, the jurisdictional issue was raised. You've done it anyway. There's no defense. So it's not really helping the person who's complaining. The thing that helps the person complain is to get to the proper avenues, is to drop a word to the building inspector to say, please put something in writing to this person. They need a response. That's, you know, that's really the way to deal with it.
May I ask a question, Judge? Just maybe it might help Woody out. I'm
Yeah.
looking at the statute right here. So under 7, section 7, 48, section 7. The building inspector shall notify in writing the party requesting such enforcement within 14 days. Okay, so he's directed to do it in writing, but the question here is, what if he doesn't?
Yeah,
Okay, so then section 8 says, an appeal may be taken by a person aggrieved by reason of his inability to obtain a permit or enforcement action. So, I mean, isn't this covering this person? If the building inspector does not issue the writing within the 14 days, so the aggrieved party has failed to get an enforcement action. I mean,
I agree. Yeah, but the courts have said no, he hasn't failed to get an enforcement action.
Okay.
There's nothing.
okay,
There's
so the courts have taken that language in section 8 and have turned around and said, your failure to get an enforcement action has to be a written failure to get enforcement action within the 14-day period.
Well, or within any kind of, I mean,
Within
they
any
don't.
period. Yeah, I mean, so then you're saying the zoning board would direct them to respond. And then that would trigger, then a written denial would be issued, and then that would trigger the person's appeal right. So they're eventually, if the zoning board is sympathetic to this homeowner because the building inspector hasn't bothered to answer, the zoning board has within its power to trigger all of these statutory requirements and timelines to allow the person to get an appeal eventually.
I don't see that.
No, I don't think so. I don't.
No, all right, well, that's what I'm asking, so.
I mean, ultimately, the courts have sort of said, well, it's just not, there's no directive to the building inspector here. He is not required to do this, and if he doesn't do it, there's nothing appealable. But he hasn't denied the permit, the request. He hasn't denied it, and that's the issue. And you don't know, he may deny it, he may not. He may take action in 2 months. And if he does, then it's appealable.
You know, since these bylaws were written in 69, the opportunity or the right to appeal has been embedded in section 12.2, and it's now removed.
No,
There is
it's
no
not.
right.
That 12.2 would have to be interpreted in the context of state law. One could not take that and say, well, I read Cohasset's bylaws giving me a right of appeal. Cohasset doesn't have the power to alter the state regulations, to alter the state procedural requirements and reinterpret them.
Well, is there a
anymore.
state regulation, or is there one case that you've cited?
No, it's the appeals court case. It has never been overturned. It has been cited by several parties, and the town can take a different position. But I'm advising you as town council that we would very unlikely be able to support a decision that flouted this particular procedural requirement. It would be the same as if you said, you know what, I know that the bylaw says you can't appeal until, that you have to appeal within the 30 days, but we're changing it to 45 because we think it's unreasonable. You may think it's unreasonable, and you may be absolutely right, but the statute governs here. And I think you have to allow the statute to speak for itself. It speaks plainly. The courts have interpreted it that way. And I think we're going out of our lane to rewrite the statutory procedures. Again, if the Zoning Board of Appeals is sympathetic to somebody who appeals from the lack of any action, the lack of a written response, and you take it under and no one complains that there's a lack of jurisdiction, I guess you proceed. But if they do, then your decision will not be defensible, in my opinion.
Or it will be litigated at least, and we'll find out.
If it's litigated, I don't think it'll be a defensible position, is what I'm telling you. Based upon my years of experience and my knowledge of the law and the reading of the law, I just don't, I cannot condone changing this to add an appeal right that doesn't exist.
For the other board members who are unaware, Judge Cutler was the Chief Justice of the Land Court, and one of the primary functions of the Land Court is the trial court that hears zoning appeals. So she knows of what she speaks. And again, we are trying to get Cohasset in this bylaw away from outlier positions and positions that are legally indefensible, that maybe we have sailed along for many decades with them, but we can't continue to have bylaw provisions that are contrary to the law. And, we have a state rep, we have a state senator. I would think the fix to this is fairly simple language. I imagine it's occurred to somebody else since that appeals court decision came out, that to address this loophole where there's inaction by the building inspector. But it's not for us to do, it's for the legislature to do. And Woody, an appeals court decision, it's our intermediate appellate court, but
I know.
it is an authority, and it is an authority as much as the legislature's authority. It's up to the legislature to take action in response to a court decision.
I mean, there is another way to address this issue, and that is through the personnel structure. So if there duties and responsibilities of the building inspector that are set out in writing in their job description and in the, in the set of what they're required to do. And it clearly states that the building inspector must respond in writing to any and all zoning enforcement requests within a timely manner. And he doesn't do that, that's grounds, for disciplinary action. But again, the zoning board of appeals does not oversee the building inspector. So that's, that's their appointing authority to deal with.
Okay. So where are we, Tom?
All right, so we're just going to scroll through the rest of this. So again, there's a section in the existing bylaw describing the zoning board of appeals. There was not a section describing the planning board. The planning board is described in the general bylaws, but we thought it made sense, since the planning board deals with this bylaw just as much, that it should be mentioned in there. And then we have, as we do in the existing section 12, there's sections about special permits and the sections about variances, and the judge has explained the changes to site plan review. And
Oh, do you want to address Woody's?
yeah, so we're
Yeah.
let's just go through the whole thing, and you can keep scrolling, Cassandra, thanks.
How far down do you want me to scroll?
Yeah, go all the way to the end, because we're going to get to the part that, all right, and so some changes to definitions, and then at the top of this page, the third step in this is to, no, actually go up a page. I'm sorry. There it is. Stop right there at the bottom there. The second step in this is deleting section 304.2. And 304.2, in the Article 4 is where we brought back the use variance and the use special permit language that had been deleted from the bylaw in 2002 and was brought back into the bylaw in 2021. And so Woody, I'll let you speak for yourself as to what your objection to that is. I guess the use variance there's no problem with the use variance, because up above here, when we discuss variances, we put in the word use. So you have the power to grant a use variance. The issue here with 4.2 is the language regarding a special permit. And what we have is language that says that anything that is not prohibited can be allowed by the zoning board by special permit. The legal position that the judge would articulate again is that under state law, no, we can't do that. We can only grant a use by special permit that's specifically allowed by special permit in Article 4 in the table of uses. So Woody has brought that up as a concern that for 6 months, if you take 4.2 out, the zoning board isn't going to have any flexibility to grant something by special permit, until we get to the point where we're again redoing the table of uses that'll address this problem in the fall.
Or by variance, because
No, the variance part is there because up above in the section on variances, we inserted the word use so that you have the power to grant a use variance.
Okay.
It's the use special permit language of our bylaw that is Judge can correct me, but in her legal interpretation is that it is not a power we can have because state law is clear that we can only grant a special permit.
All right. I mean,
So
this is
here's
going to
the thing.
be
Here's the thing.
circular.
No, I know, but here's the thing. We talked about we're talking about a 6-month period where this might be some issue, but again, the judge and I
My
talked about.
recommendation is to leave it in, and when you get the use table figured out, I'd be more than happy to stand aside or in fact cheerlead the elimination of this. But you're creating a void, and I think we've had 2 cases where Well, one was a use, and so if you've changed that, fine, but we, this bylaw which is Article 25 in 2021, passed by unanimous vote of town meeting. It went to the Attorney General's office, who approved it. And you're saying it's illegal, and because the Attorney General doesn't have the power or ability to really understand state law.
No, that's not true.
Statute.
No, well, all right, I'll let the judge
That's the
take
way
it.
I'm reading this, and
No,
this
no,
is to my mind, a legal bylaw.
I
to
don't
get rid
want
of it.
to, look, I am not suggesting that the Attorney General doesn't understand or know the law. What I said was, there was no discussion of that article. There were a group of articles that were approved, just approved with no discussion, okay?
Why do you say no
No,
discussion?
There was no discussion.
I
in the-
spoke on the floor.
No,
of town
in the
meeting,
board, I'm sorry,
or
in
at
the
the town
attorney,
meeting.
I'm sorry, no discussion by the Attorney General about why he was approving it or what it involved. It was it was just a simple sentence that's saying articles, the zoning
Sure.
amendments under articles, you know.
Does that make it invalid because they
No, it
didn't?
does not make it invalid, but it also does not make it valid. There are many reasons why the Attorney General may have not disapproved it. There is a presumption of validity. There, you know, don't forget, this was COVID. People were not in the office a lot. There may have been many reasons, or they may simply have missed the fact that there is case law on this, okay? Longstanding case law. So all I'm going to suggest to what we can do as a compromise here is not touch the language that was put in 4.2, except for the verbiage about the use variances, which is now covered under 12. When we go to Article 4 and put in very more broad categories of uses, it will allow more flexibility for the special permit provisions, and we won't need that's other.
So you're
special-
saying, actually, I misinterpreted then. So you're saying keep 4.2A or whatever it's supposed to
the
be.
part related to the special permits.
We're gonna keep that?
I said that would be a compromise suggestion I
Okay,
can make.
I would buy that,
I can
For-
make
for-
that to the committee, and the committee will have to, and
because
Yeah.
when I see down here, I saw deleting in its entirety.
that's what the original was. That's what you
Okay,
proposed.
okay.
And what I'm suggesting is there is a way to address your concern about the interim. I don't still think that's illegal, but I'm not, if I don't touch it, since we're not really.
That's right, it's
dealing-
there. I mean, what the heck?
You know, it's there, and if you want to rely on it during that interim, I guess you'll rely on it, knowing that we're going to try and fix that situation.
Sure, and so that we won't need it.
Right.
I can buy that. I just
Yeah,
was objecting to deleting it in its entirety, that's all.
well,
Now, we can, there will be a time and a time to do that, but not yet.
But I think that has to go to the committee for its
All
consideration.
right, fine.
well, I don't know that we'll have time to go to the committee. We'll decide that. at
Well,
the
if you
time.
don't, Tom.
We'll
you don't
decide
want
the
me-
planning-
You
we'll
don't
decide-
want me at town meeting.
No, I know
They-
that, Woody, but I also, you know, what this, you know, this and the previous discussion, we need to get off the idea that just because we've had it in our bylaw forever, that it is legal. I mean, the judge is trying to bring us in compliance with state law when we've had anomalies in our bylaw to the contrary. And so this will survive for 6 months until we change it in the fall. But you know, I would have to caution you, if an abutter appealed a decision, that you just can't willy-nilly grant whatever use you like by special permit if it's not allowed in the bylaw by special permit. It's going to be a legally indefensible position, but we can live with, we've lived with it for a few years and we lived with it before 2002, but we can
We've
live
lived
with it
with
for
this
another
since
6 months.
2021.
Hmm?
This bylaw went into effect in 2021. It's
Yeah.
not, it's no long older than that. It was approved by the office of Maura Healy, whether she was good, bad, or indifferent as an attorney general, she was.
I understand. And then I just want you also, and I said this to you yesterday, is that don't think the Attorney General's office is the final word and is infallible. And there can be many reasons why this got approved, and even if
did get
approved, a
approved.
court,
My only point is, let's move on. I mean,
All right.
if you're going to leave it in for 6 months, I'm not going to argue the
All
point.
right, fine, all right.
If you're going to take it out entirely, I'll certainly go to town meeting, but there's no reason to.
Okay.
All right.
Moving on. Anybody else have any questions or issues on that particular section? 12. Okay.
All right, so the last one is Article 2. By the way, there are many definition changes to Article 2, but a lot of them are being made in conjunction with the article that they relate to. So for example, that Article 12 had some definitional changes in Article 2. Article 6 did, Article 3, no, not Article 3, Article 6 and Article 12 did. But here we are isolating a few other changes that aren't connected to any particular other article of the bylaw for change. The first set of changes are small housekeeping up at the top. The one about premises was a mistake in how Article 11, it had a reference to Article 11, which was, either how it got in there, nobody knows. It was just a miswriting of a definition. The major change here is with the definition of height, which has been talked about on the bylaw committee and the bylaw working group for a good 2.5 years now. Two changes are being proposed. Number one is first of all, understand that we have a uniform height requirement in town at the moment of 35 feet. But please separate the number from the definition. Two separate issues. We are going to deal with the number if we want to change it in the fall when we deal with the table of area regulations under Article 5. For the definition of how you measure that 35 feet, the first set of changes is where you start from at the bottom. And at the present time, sometimes we get 2 data points for someone to come up with what the mean grade is. And, we don't have flat pieces of property a lot in town. And we've had some examples that have come up with some large home reviews where, just getting 2, 3, 4 data points just simply isn't enough to get an accurate sense of what the mean grade is. And so we are going to begin to require 12 measurements at equidistant intervals. So you see there where it says 10-foot intervals, that has been changed during the public hearing process with the planning board. Made at the suggestion of a couple of people, and it's well taken. Our current bylaw also says that measurement around the foundation be taken at points 10 feet off the foundation. And a citizen who participated in the public hearing said that why? It makes no sense. And we had never questioned it up to that point, but that is out too. So the 12 equidistant data points be taken at the location of the foundation or the proposed foundation. And then there's the distinction that the measurement is made from the lower or pre-construction grade or finished grade. That's to prevent any measurement of height being made from fill that somebody brings into a site. So this is already the building inspector, because of a large home project where this controversy was brought to the forefront, is implementing this as a matter of practice at this point. And everyone, developers present at public hearing, the zoning bylaw committee 5-0 approves of this change in the bottom measurement. Okay, then there's the top. And the top, the main change in the top here is that at present, our definition measures styles of roofs at the highest point, except with respect to a peaked roof, which we, for whatever reason, measure to the midpoint and then allow for 5 feet above that. This would change that and would make even a peaked roof measurement at its highest point. What we believe this does is it takes away essentially a loophole to allow a potential 40-foot structure when the town's limit is 35 feet. And it's also just logic and common sense that the average human being is going to think the top means the top. We've done studies of large homes under the large home review process. Very few push this 40-foot limit, but the trend is in that direction. And there was one particular project in the last year that did push it. So we're not necessarily solving a problem, and I don't think we always need to act to solve a problem. We are trying to be proactive to prevent future problems and to address the trends in development to maximize sizes of buildings and not allow this loophole that we could have a 40-foot high structure in any of our districts, but particularly in the residential districts, to occur. On the zoning bylaw committee, there was a 3-2 vote to support this. The planning board has not decided on it yet. Again, wanted to wait for your opinion and advisory. Advisory is supporting this change 8-0, both aspects of it. And that's where this is. That's the change. It's the change of how we're measuring height on a pitched roof. Now, it has come up that, well, maybe this will defeat building multifamily housing that we're going to have to build. And maybe this should be taller in the village. And maybe it should be taller on 3A where we're going to do the multifamily. And that may be. And I will tell you that the committee has actually talked about lowering the 35-foot height limit in the harbor. That's the only place we have to date discussed changing 35 feet. But if we want to make accommodations for taller structures on 3A, it's fine. When we get to the table under Article 5 in the fall, we can choose to do that. If we choose to allow accessory dwelling units over garages, we can address the 15-foot height limit on garages. But that, again, the number is a different issue than the common sense of the definition and not having a built-in loophole with respect to peak roofs. I can tell you that the public sentiment that gets expressed through large home reviews that nobody wants to see 40-foot high buildings in the residential districts. I think there's a lot of sentiment on social media not to have it in the village either. And for the record, the current 55 South Main that's under construction is not at 40 feet, and the building at 1 Pleasant Street is not at 40 feet either. The one at Pleasant Street at 1 Pleasant is a peak roof. It has 3 stories of usable space. It's made use of dormers. The height is 33 feet to the midpoint. It's 37 and change to the peak. But I don't know that there's a sentiment of going higher, but both of these buildings, or certainly 1 Pleasant Street and certainly most houses can still accommodate 3 stories with a peak roof measured 35 feet to the peak. So we don't think it's creating any hardship for anybody, but we're trying to anticipate what's coming down the pike and the trend that we're seeing in the sizes of houses. That's all I'll say on it. And I don't know if the judge wants to add anything to that.
Board members, anybody have comments or questions? I'll just throw in one comment.
Mhm.
I'm of the school of thought that any citizen should be able to read the bylaws and understand what they mean. And I think that having the height be the height is a good change.
Thank you.
Yeah, I wouldn't see any downfall in adding the additional data points on the pre-construction height and having it be, 12 measurements around the entire perimeter. I don't see a downfall in that. I think we've had 1 or 2 cases where we've taken a look at where those data points came from and if they were the best result. So I
No,
do. think
and nobody disagrees with that. There's been no expression of opposition to that, to the bottom measurement at all.
Yeah,
But there was a project that abused it about a year and a half ago, and we're not sure to this day whether we got a true measurement of what the mean grade is at the bottom. Okay, well,
I've got two concerns. What do you expect? I don't have any concern with the peaked roof of a dwelling at 35 feet. However, the other two concerns are that the language here references buildings and other structures. And as we've all talked about, other structures could be anything from a tennis court and a swimming pool, which are not particularly relevant when it comes to height, to things like light poles, flag poles that are now capped at 35 feet, whereas the zoning board has applied a certain amount of judgment, particularly in the question of lights and spillage onto neighboring properties, and has basically come down in favor of 10, 12, in one case, 14-foot light pole. But to make as a matter of right, allow somebody a light pole of 35 feet, because that's what the definition of height other structures is. Nobody's going to put a 35-foot tall mailbox. I'm not worried about that.
No,
But
this,
I think this is a mistake. I think I would eliminate the word structures and leave it to be buildings, and I think I would be comfortable.
Woody, this doesn't set the height limit. The height limit is for any structure is addressed in Article 5, the area regulations. So this doesn't say anything's about anything being 35 feet.
So what does it say about light poles in Article 5?
Well, if there is a height limit in our set for light poles in Article 5, that would be how we measure. How we measure it would be in this particular.
And it's not in there. The only
If
place
it's
it's
not
in there
If
is,
there's no regulation, then there is no regulation for a light post.
so we have applied certain principles of light spillage and things that will prevent somebody from putting, let's say, lighting a tennis court at night.
Probably.
With very tall, and we've had suggestions from applicants that haven't materialized to build, really tall structures. And
And if there's no limit in the existing
then we can judge it on other grounds.
then you judge it on other grounds,
No.
or you can decide to put a limit on it. We can do
Right.
that when we get to Article 5.
There could be, but at this point, I would eliminate the word structures and leave the word buildings.
No, because we still have to measure certain structures do have height limits. For example, freestanding signs would now have a height limit. So how do you measure that? Well, this tells you how to measure that. It's to the very top,
Yeah,
because this has two alternate, maybe we need the language of the actual definition up so you can see what we're talking about. This is just a summary. So
And I think in the area regulations, there's height limits on walls, flagpoles.
yeah,
there isn't on flagpoles, I don't think, Dave, is there? There's
Well,
one on
I'm
lights at
looking-
the at high school or school playing fields of 70 feet, which is a little.
I'm looking at the bylaw right now. In many places, it says any permitted structure or principal use, and we have 35 feet everywhere. And we discovered that we don't have a height limit on freestanding signs, and we're fixing that.
okay, so this
Frankly,
is,
nobody's brought this up, but the town in its wisdom hasn't addressed this forever. And when we get to the fall and do the table, I guess we're going to have a new line now that's going to say, accessory structures such as light poles, flag poles, blah, 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 and put 12 feet, whatever it is we put.
I think,
Because,
I think that's very situational, particularly when it comes to issues of lights.
again, but that's
But
dealing
a
with.
structure is not a building.
Well, no, but if you look at the definition of height here, this is not building height, okay? It's the vertical distance from the lower of the pre-construction grade or the finished grade to the highest point of the building roof, or the highest point of any structure other than a building. So, in other words, just so we know how are we measuring every structure? The height of a structure is measured that way. And then whatever that actual height number is going to be found, if there is any limit, is going to be found in Article 5.
Yeah.
It's
and
like,
because
it's
it
like the
isn't-
definition of lot area. You're not putting in 40,000 square feet or 20,000 square feet into the definition. That area requirement is found in Section 5.
Since we don't have any, well, you have a sign structural thing now, and we have basically the high school football field lights. Those are the only two structures I can think of with, oh, and fences, sorry, and walls at 3 feet, fences at 6 feet. But that leaves a very large, void. I'd rather take the word structures out, but if you want to put it in, okay, but I'm very uneasy about the variety of structures.
So you wouldn't measure a light pole from the pre-construction grade?
I
or
would,
finished-
but without a height limit. I was just so I know how to measure it. What good does that do if there's no?
Well, because definitions are not regulations. Definitions help you to understand the regulations. So if the regulation says this is the maximum height, you look to see what height is.
Okay,
It's just a reference point.
Yeah, and
I'm just saying, I think it's, all right. Well, my other concern, and you all are aware of this as well, is that much has been talked about tonight about 35-foot versus 40-foot buildings, and the issue is massing, and I'm very much in favor of 30 feet, 35 feet on a peaked roof house. But what's being reduced by 5 feet are also permitted accessory buildings. Let's call them a garage. And if you take 5 feet off a typical 15 to 20 foot garage, you're left with a 1-story garage. And it's my hope that when the time comes in the fall or in the spring or whenever we're ready for accessory dwelling units, mother-in-law apartments above a garage, which are very practical for people who wish to downsize or starter lodgings, kids coming back. I worry that a garage, it's not practical to have a garage whose peak is 15 feet. It's maybe very practical or innocuous to have a house with a 35-foot ridge line. But I worry about just taking a simplistic measurement, or we'll take five feet off everything. And we'll apply it to garages and any sort of permitted structure of a non-dwelling nature, or maybe a future dwelling nature, but portion of a main building, less than 15 feet in height. You're
Woody,
going to prevent a,
it's
Woody, I don't understand where the taking 5 feet off is.
because the definition of height is to the ridge line, and the bylaw says height will be 15 feet for a permitted accessory building.
I don't see that. Where is that?
Okay, well, which district do we want to go to? Let's go to
no,
RA.
he's right, is that the definition of a peaked roof applies whether it is on a house or a garage.
Right, but when
Our garage height limit is 15 feet.
well, what it says is permitted accessory building may be
Yeah.
constructed no closer than 3 feet to the sidelines and or rear lines of its lot if less than 15 feet in height and 75-foot setback. I don't see where it says there's a 15-foot height limit on a permitted accessory building.
Yeah, only if it's, okay, only if it's within the setback there.
Yeah. So I think if you had you know, an accessory building that was set on a large lot somewhere, you know, far from the lot lines. I think they just don't have that limit. Maybe is there another provision that I'm missing here?
No, you aren't. Underneath it is a portion of a main building less than 15 feet in height. Typically, this would be some sort of a, you know, kind of a garage kind of appendage, but an attached
Yeah.
garage. But again, it's deals with side setbacks. It may not be that big a deal, but I would worry about kind of arbitrarily kind of compressing the height of a garage, which to my estimation only, it's anecdotal as everybody else's is in this process. Not the massing issue that worries our citizens. It's the principal structure massing that's at issue.
Well, again, I urge not to conflate the issue of the number that we apply to height with the definition. I think we all agree the definition makes sense from a lot of perspectives. And I don't, you know, the argument has been made to us, well, this isn't going to prevent 3-story buildings. No, it won't. This is going to prevent a garage with, you know, cars on one level and space above. No, it won't. And we don't allow the mother-in-law apartments. They exist, but we don't legally allow them yet. And like I said
hope
earlier,
we will, but we don't. You're right.
if we make the policy decision to allow ADUs to expand to outbuildings on the property, then we'll deal with the height accordingly at that time. And you know, we're pointing out that, you know, the table in Article 5 is also something that's in need of a lot of housekeeping and change, even if we kept current numbers. But that's when we'll deal with that. And, you know, I mean, we can do anecdotal. I know somebody who's got a room over a garage. It's the, you know, it's the man cave for football, and it's not a 15-foot high structure.
I think at this point, there would have to be a general overhaul anyway, because you have, right now, if it's 15 feet or smaller, it's conforming. But if you want to put an apartment on top of it, you're creating a new nonconformity. You're going to need a variance, unless the issue is
Yeah, unless we change the
fulsomely addressed
bylaw.
and change.
Yeah, unless we change the bylaw to allow accessory dwellings over garages and sheds and things of that nature, which is, you know, Woody was the presenter when we presented in a public forum on ADUs, and that's one of the options on the table. But we haven't gotten there yet. And we'll, you know, obviously, if we do allow them to be built over garages, we're going to have to rethink the height limit accordingly. The definition won't be different, but the height and the number applied to it will be. We have to adjust.
I mean, right now they're pre-existing, so any change in the height definition is not going to apply to them anyway.
Right, it's new construction only. You're right. And I don't know. It's just that a lot of people have used the space above the cars on a detached or on a, well, it's got to be.
But you can do that within 15 feet with all due respect. I mean, you know, the other towns in their definition, they put 35 feet or so many stories and they define story. And, you know, and for residences, I spoke to an expert at a state seminar I was at Saturday that the rule of thumb for residential is 10 feet is a story.
Yeah,
And-
I mean,
and even
as I
that's
say, I have no
generous.
issue on the residential
Well, 10
portion or the home itself, the dwelling itself.
But
most
10 feet
buildings.
10 feet is a generous story for a car. So there will be space above. There'll be plenty of space above the
5
area
feet
needed.
above the cars.
Well,
its
that's
peak.
only for the garages that are close to the lot lines.
Right.
The others aren't subject to that 15 feet. And
Yeah.
we're talking about new construction.
Yeah. Yeah, a big property can have a barn that's 35 feet high, you know. And-
Okay. A lot of, all right.
But again, you're bringing up great points that we need to address with the table. And again, and other people have brought up.
This is not a fall on my sword issue. But it is a question of, sort of compatibility, citizen compatibility, neighborhood compatibility. Is it a big problem or a little problem? And I think you've addressed the big problem, which is the height of, or are addressing height of the dwellings that start to push the envelope. I just think this is not a particularly egregious issue, but it's also not something that, I'm
In a
gonna,
perfect world,
know.
we deal with, in a perfect world, we would have dealt with this bylaw all at once, but that was deemed by many to be on the bandwidth of everybody. So, it's hard to break this. It really is hard to break it up into pieces.
yeah.
Because
My
there's so
general
many-
premise for the purpose of the board is not to be a complete raving jerk here tonight. But it is to say, although I did get a smile or two from people who are thinking that way, but it is to say, if you're going to change something, do it as an entirety, as opposed to pieces, or we're going to come back in the fall, or we're going to come back next year. And I'd rather see things left alone and worked on, and then say, we have a package. We've thought about all the little nits and gnats, and it's a coherent whole, as opposed to wait until we come back to you. That's all. It's more of a
know.
process issue than.
I know, but
and the content
that
issue.
decision was made a long time ago to break this up into pieces.
Yeah, I just,
So,
And I just might want to point out, if we presented you with an entire new bylaw, think of the discussion we've had on it, how long we've discussed a definition. Imagine if we had a 50-page new zoning bylaw that we had to have
oh,
everybody.
yeah, no, that would be,
It would take forever.
I think
yeah,
it's,
no, I'd move
I
out of
think
town before that.
Yeah,
what we're kind of doing here is trying to foresee unforeseen consequences, which is a difficult thing to do, but it's worthwhile.
Yeah.
And, we have the expertise to be the most likely people to see them. But I do think that cleaning up this height definition on peaked roofs is important. And I don't really believe, it's on new construction, so I can't really see that it's going to create any issues that we can't foresee.
Yeah, I think the biggest job in front is going to be the table of uses in many respects.
Mhm.
And, it's 55 years old almost. The computer wasn't invented. A lot of things weren't invented. We allowed animals in the harbor.
Yeah.
Farm animals.
they're restricted.
They're well covered, but.
They're restricted. They're restricted under the new proposal. What you're going just so to give you a heads up on that, what the thinking, and Woody knows this from the working group because we started this thinking back then, is that the laundry list that we have in the table of uses is created problems. It made Crazy Paws go to court to be allowed to open. So we're going to a concept of having broad categories of uses. For example, like, retail without doing a laundry list of retail. We'll continue to prohibit the uses that we could currently prohibit that we don't want, like fast food, adult uses, that kind of stuff. But otherwise, we're far from the highway. We're trying to maintain 3 commercial areas. My own view is we're in a beggars can't be choosers thing, and we have to give people flexibility. And so by going to broad categories of uses, it's going to make it easier for all of us on the boards to accommodate ideas and to accommodate businesses that want to come and locate into the town. So that's where we're heading in that direction. But it's going to be a daunting task, and the table of area regulations is going to be a daunting task, depending on how much of it we want to change. And there's talk, but there's no decisions that have been made on how much of that table we want to change.
Okay, is there any more discussion about this particular piece? Okay, Tom, what's next?
That's it.
All right.
I hope we can get some recommendations, but again, the key thing is to have recommendations available for print. We will be going to the planning board tonight to finish with their votes on Article 12 and Article 2. I don't know what the selectmen are doing right now, but they are going to vote perhaps on 3 of them, the 1, 3, and 6. We're going to go back to them on the 4th, so, I'll be appearing there. If you're going to take a vote on the 4th, I just want to make sure we have coverage to watch and answer questions, but unfortunately, your meetings are conflicting with select board meetings, but can't be helped. No problem.
Is this on our agenda for April meeting?
It will be. I
Not
mean,
currently.
I think the first 3 I feel comfortable voting on. I think you guys can all take a vote if you wish, and the other 3, I'd like to ruminate a little bit. I mean, I've heard some concessions here on both sides, and in orders of magnitude. I mean, something's a murder case and something's pretty benign. I'd rather take the final vote on the 4th, but if we want to just get those housekeeping 3 articles out of the way, I'm comfortable. I'm not comfortable yet until I internalize and see the final language of a couple of these other 12s and 8s.
Okay.
But I don't know. I mean, that's just I
don't know. Did we?
I'm one of 6.
We didn't have a lot of changes, I don't believe, other than.
Tom, is it essential that we do anything tonight? Can we just give you everything after our next meeting?
I would love to be able to tell my board tomorrow night that we've made some decisions. But of course, you're probably not going to make a decision on 12 and 2, which are the remaining 2 things we have to vote on. But yeah, whatever. I just, my concern is that if the judge and I are with the select board on the 4th, we can't be in 2 places at once. And, to the extent there's more questions, I guess I would ask that if there are questions that you individually get them to me ahead of time, and I can try to answer them. The judge and I can answer them.
My question, Tom, would be, because a couple of things have changed, like height, removing the every 10 feet thing. I know it's small, but it's out. If we could get at least the latest and greatest textual copies sent to us, I'd feel a lot more comfortable with that. Because it is, and it's probably going to move a little bit more. I mean, it's between now and
I'm
the 1st of
hoping
April, but I'd like to see it in writing. The
No,
summary
I hear you. And
didn't get at everything that I would have liked to have seen.
That was an issue with the planning board last week. I mean, these things get up online, they're on the bylaw committee website, but again, it's judge's workload, mine, Cassandra's, we'll get them out to everybody.
Well,
But I want to
when you
avoid
feel comfortable, when you
Well, I
feel,
want to avoid like the plague, having amendments on the floor, so,
yeah. No, I'm between now and, I mean, just.
yeah. But I'm not gonna
Planning
speak
board
to,
and there may be
I'm
some
not gonna
other
speak to the
tweaks.
judges and Cassandra's schedule of when we'll have the text.
Dave,
guess-
what do you think? I'm thinking maybe next week if we could get a semi-final, the most final available
Yeah,
text.
if we can get that by next week, it'll give us all a chance to digest it. Any
yeah.
questions that we have, we can get to you. And then
Other
we'll
than the
have
ones
your
that the
answers by
planning
the
board
time
hasn't
meeting is
already
over.
approved, we can get you the final versions of what the planning board has approved.
Yeah.
I mean, that's pretty easy. There's only a couple of little minor changes that we have to make to
Right.
the text, so we can get you that in the next couple of days, I would think, right, Cassandra?
As far as I know, everything other than 12 and 2 have been updated. So,
Okay.
I mean,
Yeah,
they're-
well, I'll
they
check to
have
make
them.
sure. I'll
Yeah,
check.
they've been updated in the text, but not necessarily in the judge's summary, but the
Yeah.
text is the most important, so.
Right.
Yeah, we should be able, if you're gonna shoot for a meeting next Tuesday to vote, you should have everything by the end of this week. I'll commit the judge and Cassandra to that possibly.
Try and get it done tomorrow.
And I would ask you to think, even if it isn't within our purview, think of ways that we could solve my unease about enforcement of non-actions. If there is a way that's legal, fair, understandable, Not to put an undue burden on any one, be it the building inspector or an aggrieved party or whatever, but is there, the principle of, gee, if you're aggrieved, I think a citizen has the right to appeal. Now, they don't have a right to win that appeal, and they don't have a right to tie a hardworking person up in knots by filing dozens of appeals. But the kind of things I think that we see in the zoning board, I let Dave or Lee or anybody else speak for Matt, speak for themselves, are people that think they have a real legitimate beef. I mean, that's 9 times out of 10. Whether they're right or not is maybe a slightly different matter, but they're not doing it to harass somebody or to get airtime, So if there was some way to facilitate this.
And they're usually, a good part of their beef is that they think that someone is not doing what they're supposed to do or what the bylaw says they're supposed to do. And as a result, they're being treated extremely unfairly. And they're right. They're absolutely right.
Have you had discussions with the building inspector about his processes?
I don't know that the non-action is an issue, but my concern more is with the notice issue. I'm very concerned about that.
Well, is a matter of practice. I mean, again, if I didn't know anything about this appeals court decision, I'd look at section 7 and 8 of chapter 48 and say, yes, there is a process. It says the building inspector shall issue his response in
Yeah.
writing. Is he doing it? Is he at least doing that? So that the person who's making the complaint is at least getting a written response?
Has that
Well,
been
the
a
problem, I think the problem is what it says is within 14 days.
Yeah,
And what happens is, as the court recognized, there are many reasons, legitimate reasons, why a building inspector can't get a decision in 14 days.
Mhm.
It could be something simple as he needs more information, or the request was very vague and he doesn't even know what they're talking about.
Yeah, that's probably more the latter, but
So or that he may have thought he already answered that question. Maybe he was
Yeah,
talking,
well.
the person was in talking to him and he told them, no, it's perfectly fine. And then he gets the written request and he says, I've got other things to do.
I know, I get it, but
There's
certainly
many
if he
reasons
can do it as a matter of habit, it's fine.
some towns must have figured out how to do this fairly and efficiently as opposed to illegally or with the, bureaucratic,
Their towns follow state law, and as I said, they may consider it, but if somebody raises it as a jurisdictional issue, it's a problem.
yeah, would you mind sending in maybe to Cassandra the case that you've cited?
I
I'd
can tell you right
personally
now,
enjoy reading it.
it's Elio, ELIO versus Zoning Board of Appeals of Barnstable. And that's 55 Mass Appeals Court, 424, 2002.
Okay, I mean, so this is really not necessarily within the purview of the zoning bylaw committee, but
Right.
it does have to do with process that we run into a lot.
Yes.
And
those processes can be dealt with in other avenues. There may be
Yeah.
policy directives that come down from the appointing
so
authority.
there may be something here that with the select board would initiate or endorse and,
Exactly.
yeah, I mean.
Yeah.
All to
And-
the good. I mean, all to the benefit of our citizens, I think.
Mhm. Yeah.
And the notice problem Dave speaks about has been perpetual, nobody, because even when there were newspapers, local newspapers.
But that's a landmine, as Dave
Who-
points
who
out,
read
if we're not
the legal
following our own
notices?
town
Reads
bylaw.
Who read the legal notices on a
It
regular
doesn't-
basis?
That's not my concern. If it's published in the paper and they
Yeah.
don't read it, that's not an
Shame on them.
excuse. This notice is there and we can see the date that it was published and we
Right.
can measure the time from that date. But when it says that that's how you do it, and then you do it another way, we don't have
Yeah.
any way to measure when they got notice.
Our general bylaw we can fix. The the fixing section 7 and 8 of chapter 48, we might not necessarily be able to fix.
No, that's a different story.
Yeah, so.
So that was a
Anyway, well-
request, a general request, not so much of zoning
Okay.
per se, is not zoning per se, it's,
No, but somebody has to bring it up, so.
well, I don't,
We got a zillion things on the plate, what's another?
well, that may be not a burden that you should shoulder. As much as just tee it up and say this is an issue.
I welcome volunteers with the effort. Anyway, if there's nothing, I mean, I don't know if you want to vote on those three, I would appreciate it, but if you want to wait till next Tuesday.
I'll leave it up
that's
to
fine.
Dave to decide as our chair pro tem. Oh, wait a minute, Charlie.
Charlie, you're muted.
Okay. Now am I muted?
We can hear you.
Good. I would prefer not to vote until I can read some of this stuff in writing. It's very complicated and I'm impressed by the work you put into it, and it basically sounds good, but there's a lot of little intricacies that you've got to sit down and think about. So I'd rather not vote tonight.
Understood.
I think you have a pretty good sense of where we
Yeah.
are on everything, so.
Yeah.
The easy ones, yeah, I think you can assume they're easy ones.
No, I
And-
appreciate that.
How is it best to get the updated versions that there are to the members?
Me.
Just Get them to Cassandra and she gets them to us.
So that's by email? So is
Mhm.
everybody gets email? Okay,
Mhm.
just to make sure.
No, I know.
All right, well, if there's nothing else, we'll let the judge go. I appreciate your attention
Thank you very
tonight.
much.
Yeah, thank you.
Thank you. Thank you. I mean,
Thank
you know,
you.
it's,
Thank you all for your patience.
And you all know where to find me, so thanks
Tom,
again.
thank you for all your work. I really,
Appreciate that, Lee.
I know your hobby, but you put so many hours into this. I just
He has. He has.
Wait till the fall. The fall will be a real. Judge thinks we're biting off too much, but you'll wait and see. But all right, thank you again, though, and I'll.
Okay, yeah,
I'll
thank
set
you
up a
very much
meeting
for-
next week, just
spent
let
a
me
lot
know.
of time tonight. I appreciate it.
All
Yeah,
right.
no, it's great. I appreciate the time, so
All right.
just
Thanks,
let
everybody.
me know about next week. Thank you.
thank you.
Okay, thank you all. Thank you, Cassandra.
Thanks, Cassandra. for
This is
your-
a little extra.
Do you want to officially adjourn?
Yeah, is there
Yeah,
any,
so I'd make a motion to adjourn.
I'll second.
Moved and seconded, Woody Chitik, aye.
David Morris, aye.
Early, good to know.
Matt Watkins.
Lee Darcey.
Mike Dickey, aye.
Great.
All right.
Okay, moved to adjourn. Thank you
We
so
are
much.
adjourned. So
Night all.
thank you, everybody.
We'll have to do this every 6 months.